You're Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Mark and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651 645 2922 or visit www.milburn.com. Hey everybody, welcome back to You're Free to Go. We're glad you're with us today, and we're going to have a fun episode today, you guys. This is going to be we could call it bloopers episode, but first I have to remind everybody, please comment, subscribe, and like our episode. We're getting lots and lots of followers, and we want to just keep it growing, and that's a big help. So, and by the way, don't forget that subscribing is free. It doesn't cost you a penny. So, as they say, like, comment, subscribe. Again, we appreciate that, and we thank you for tuning in every week for our You're Free to Go episodes. Mark is out in LA. I'm here in the studio all by myself, missing my buddy Mark. But modern technology allows us to communicate and bring our episodes to you and not miss a beat. So I hope you're well out there in LA.
Yes, everything's great. Beautiful sunny day.
Yeah.
Love the weather and raring to go. Want to hear your stories. I have one today that actually it's a subject that people ask me about all the time, which is what happens if your client lies to you about something fundamental and you rely on it?
And
What happens in
yeah,
that situation?
and we have that happen. We have that happen a lot. So
Yeah.
I look forward to talking, and I'll hopefully have some to add to your story because I've had that experience too. So let me just I have a lot of little like vignettes, I'll call them, but and everyone, these are bloopers related to criminal defense and our practice as criminal, litigators and so forth. We wanted to do a blooper episode because a lot of the feedback is that they enjoyed episode 12. Episode 12 was all about funny things that happened in the courtroom. I remember mentioning, or in the process of litigating case, I remember mentioning on that episode about a prosecutor when I was a prosecutor who came to me and talking to me, and he ripped his pants open right before the jury was about to walk in the room, all the way down from his waist to his ankle, and a bunch of other fun stuff. And people seem to like that episode, so we want to bring it back for our fans. And we've shared so many amazing stories with you guys, and we have years and years more to share with you, but they all kind of start to blend together sometimes. And one, I don't remember if I mentioned on the episode 12, it has to do with how people get nervous sometimes to go to dinner or lunch with us because they always say to me, hey, if I'm seen with you, are people just going to assume I'm meeting with you because I have a criminal case going on? So it is kind of a joke that I have with my friends when they get a little nervous about being seen in public, like one-on-one with me in a power restaurant having lunch. I know Mark worked on a very famous case, the Scott Rothstein case. We've talked about it before, where he was, photographed by the media when he was having private lunches. Well, they weren't so private; they were in restaurants, and so people see us with somebody at a serious lunch, and they sometimes just assume, oh boy, I wonder what they got in trouble for. And it reminds me of a story that I may have shared already in episode 12, but it's so good it's worth repeating. It was when I was just dating my wife, maybe a month or two into dating her. It was very early on, and we were in a restaurant. And of course, she knew I was a criminal defense lawyer, and we're having a lovely meal together. And someone walks by the table, sees me, and says hello, and I introduce them. And he turns to her and he says, boy, guy saved my life. And she turns to him and says, how did that happen? How do you guys know each other? So I very quickly thought to myself, we just met. We've known each other in the community for 100 years and, just been good friends, mutual friends, and we see each other all the time. And as he walked away, I turned to her, who is now my wife, and I said, I'm not a heart surgeon, right? And she said, yeah. She goes, well, when someone says they saved my life, it typically means that I kept them out of jail and saved their freedom. And she got it very quickly that whenever we meet someone random that comes up to me, she cannot say, how do you know each other? Because odds are I defended them at some point and hopefully saved their life. If they're out free at a restaurant, then I obviously saved their freedom. So she learned very quickly, you don't ever ask how I know when someone randomly walks up to us. But I'd love to hear, Mark. We do have clients that misrepresent things or don't, sometimes intentional, sometimes not intentional, where they don't, we tell them, you have to open up to us. We're only as good as the information you give us. But sometimes they don't tell us the full truth or all the information that we need to do our job. And it can create, funny scenarios as well as serious problems. So I'd love to hear the one you're going to share with us, Mark.
Well, the more years you spend doing this, the more experienced you become, the more likely you are not to believe your clients, certainly not to believe them wholeheartedly. And you do that for a very good reason, which is that you don't want to step on a landmine based on what your client's telling you and not only blow you up, but blow up the client. And so you're always telling the client, you need to tell me the truth. Um, don't BS me because it's only going to blow up in your face. But no matter how much experience we have and how smart we may think we are, we're always subject to getting snookered by a very sophisticated or client who is a very good liar. And I had one, and I wanted to share this because I actually ran across a court pleading recently that reminded me of this. And I'm going to read part of the pleading later, but first let me set the stage. I have a client who was a stockbroker, was accused of stealing money from three different clients, three separate types of schemes. The details of the schemes are not really that important for this, but needless to say, he was accused of a lot of fraud.
Okay.
First, he was sued by the SEC, the Securities and Exchange Commission, because he was an investment advisor. And during the course of that lawsuit, the U.S. attorney decided to start a criminal investigation and ultimately indicted him for the same conduct. And that can happen. We call it a double barrel shotgun, where you're both civilly sued by a federal agency, in this case, and prosecuted at the same time. Usually, what happens in those scenarios is you get the civil case stayed while that is frozen while you are litigating the criminal case. And there are a lot of issues that abound as a result of those parallel, what we call them parallel proceedings. But in this particular case, during the course of the uh, SEC litigation, my client gave me a number of documents which he represented proved that his story was correct and that the witnesses against him were lying. And they were in one instance, it was a form on the brokerage firm type of form that showed that this particular individual authorized a payment uh, for the purchase of a car, which ultimately was for my client. And, the form looked it was a legitimate form. It looked perfect in every respect. And I'd heard my client's story, and he had told me a somewhat plausible story. And now seeing the evidence in person, it was something that I was then prepared to use in the litigation. And there were actually two other documents of a similar nature involving the other two victims. Needless to say, I put them forth in the litigation. And during the course of that, I got a call from one of the SEC attorneys saying, you might want to take a good hard look at the very bottom of this form where it has in almost microscopic writing the date that this particular government form would start to be used.
Oh boy.
You looked at that, you see that it was 2 years later than the form was signed allegedly by the victim. So
Oh,
now we know the forms are phony.
right.
Turns out there were issues with some of the other two forms. And overnight, not only was there a clear-cut problem with defending the the SEC case, the civil case, the U.S. attorney decided to not only indict the client for the frauds that were mentioned in the SEC case, He also indicted the client for obstruction of justice,
Oh,
for using those documents
sure.
in the litigation. So the case proceeds now towards trial. Now, let me tell you this. My client had serious medical problems. He had been a veteran who had been injured as a result of a uh, grenade explosion, and he suffered medical and physical and mental problems, including PTSD. And he was found to be 100% medically disabled from the Marine Corps. And showed me a lot of records which justified this, which explained his problems.
Which, by the way, he showed you the medical records, so you documented everything. But I can't tell you the number of times I've had clients lie about a medical problem thinking it's going to get them out of jail. They come in, oh, my doctor, says I have this, I have that, da, da, and they're like, they don't want to put me in jail if I'm sick, and they're gonna not be able to treat me, and it's a liability on them, right? I get that a lot. And then I said, okay, well, get me some documentation from your doctor. And sure enough, that oh, they can't write the letter for various reasons. And so it's really obviously doing the right thing as a lawyer to say, get me all the documentation. But that does happen a lot with me, where clients just say, oh, I'm really sick, I can't go to jail, and it's just simply a lie.
Yeah,
Maybe they have.
and
Yeah.
that's something that you obviously want to guard against, and you certainly want to maintain your credibility with the court, and you want to make sure that anything you represent to the court is something you can back up so that you can protect your client's interests. And in this particular case, my client wound up supplying me with over 700 pages of medical records from the VA,
Wow.
various
Oh.
doctors. And on its face, it looked absolutely compelling that he had serious medical issues, to the point that he was explaining to me that he was having trouble walking, he was in severe pain, he couldn't stay awake, he was constantly becoming unconscious. Various items that taken in combination caused us to believe that he was not competent medically and mentally to stand trial. And we actually filed a motion to that extent. Around that time, the U.S. attorney woke up on an issue that I don't know why he didn't see this on day one. That is, that I had a conflict in continuing to represent the client, because I was the one through whom he placed the documents into the court record, even though clearly I was not aware at the time that these were false documents, and the U.S. attorney was not alleging that I was aware. But because I was the conduit by which it went into the court records, the U.S. attorney could have potentially called me as a witness, even a witness against my own client.
Oh boy.
Clearly, under those circumstances, I couldn't continue to represent him. So they moved to have me disqualified from representing him, which the court granted, and I clearly understood. The client then went on later on to plead guilty. Obviously, the evidence against him was fairly overwhelming, and now with the complication of using false documents, he pled guilty after the court decided that he was competent to stand trial. And ultimately, he got a 5-year sentence. And
Did you
I have
know
not,
the attorney that took over his case?
excuse me?
Did you know the attorney who took his case over? Was it a
I
colleague?
actually spoke to the attorney because, as you know,
Yeah.
when we take a case over from somebody else, or in those instances where someone takes the case over from us, you cooperate. You want the prior attorney to cooperate with you if you're the new attorney. And if you're the former attorney, you cooperate with the new attorney. You got to bring them up to speed.
Yep.
So I was in constant contact with the new attorney,
Right.
especially as it related to the issues of his competency to stand trial.
Yep. I know
So,
sometimes it's not the scenario that you're sharing, but sometimes there'll be a substitution of counsel. Yours was different because the court determined you had a conflict and had to withdraw. But I'll have a client come to me, and I know you've had this too, where they were with another attorney. They weren't happy with that attorney. They wanted better counsel. They switched to us. And then we reached out to that attorney to get the files and all the discovery that they received from the government. and often they'll give us a hard time. They'll say, "Oh, the client owes me money. I'm not going to provide it to you." And the predicament that puts us in is that the government sometimes takes a hard position that we're only required to provide the discovery once, and we've done it, we've lived up to our obligation, and you better go get it from that other lawyer. At the end of the day, professionals typically, do the right thing ethically and so forth and under bar rules, and they provide it to the new attorney. But it does cause a little bit of friction between the old attorney and the client, where they try to use that as leverage. Hey, pay your bill, or I'm not forwarding it to your lawyer.
Yeah, ultimately, you can go in front of the judge in the case and compel that attorney to turn over records, regardless of whether or not they were properly paid.
That's right. Now, that's because, again, we're talking criminal law where people have a
Yeah,
constitutional right to confront their accusers, defend their case, and so forth. In civil, it's a little different. There are liens that lawyers can put on files, and there's different mechanisms. But when it comes to criminal, when someone's freedom is at stake, the judges are very strict with the prior counsel that, hey, you need to turn this over so this defendant and his new lawyer can properly prepare and defend the case. So, sorry to interrupt you on that, but
no, no,
yeah,
that's a very good point. That's
yeah.
exactly what happens. And in the course of telling our stories, we're obviously educating our listeners as to how things really work within the judicial system, both criminally and sometimes civilly.
You're right. They find hopefully our stories interesting, educational, like you just said, and occasionally we try to be funny.
Yeah. Well, I've
Yeah.
got some funny stuff that follows from this.
Okay, let's hear.
So, anyway, the posture is I find out that the judge denied his motion to avoid trial. The judge declared him competent, and apparently he pled guilty and he got a 5 year sentence. I lost track of the case, and I don't remember the reason, but recently I was surfing through what we call the PACER system, which is the information system we access to look into the court docket on a particular case. And I happened to pull up his case, and I discovered that after serving, a year or so of his time, he hired a lawyer to file a motion for what we call compassionate release.
Yeah.
A lot of times these are filed when people are very, very ill and they are in dire need of treatment, in serious situations where they are actually um, terminally ill.
Yep.
Or there are other bases for these motions, and they have become fairly popular lately. Lawyers file them on behalf of clients. So I saw in the court docket the order denying motion for compassionate release. And as I started reading it, I said, oh boy. So I'm going to read certain portions. Obviously, I'm
Okay.
not mentioning the client's name. Court says, denies it and says there's no question that defendant has some medical concerns. There is also no question that defendant consistently demonstrates a willingness to lie and scheme about those conditions if he thinks it will help him.
Oh,
Then it says during the course of the case, and I'm reading various portions
right.
because this is a very long order and a lot of it is would be boring. But during the course of the case, defendant claimed he was physically and mentally unable to stand trial. Defendant appeared in court in a motorized mobility scooter and appeared unable to perambulate. He was also accompanied by his emotional support dog,
Uh-huh.
who allegedly could tell if he might become unconscious and lick him to warn him.
I've heard
Now,
of emotional sport dogs doing some amazing things, but that one I've never heard of.
well, let me tell you
Yeah.
about this emotional support dog because while I was on this case, when we had a very important hearing early on in the case, my client told me that he was going to bring his emotional support dog. And I said, well, I don't know if you can bring a dog into court. I'd never experienced that before.
Right.
So check with the clerk of the court.
Except I've seen seeing eye dogs in there. I've seen
Yeah.
seeing eye dogs. Yeah.
If the dog was what's the term? It's like a higher level of certification than emotional support dog. I know our listeners probably know this, and I at one point did remember what it was, but he had this dog certified in such a way that according to the court rules, the dog was allowed to accompany him. So I said to my client, meet me in the little patio area outside before court, and then we'll walk in. So as I turn the corner and I see him sitting in the patio area, his back to me, and I don't see the dog. I hadn't met the dog or even had him describe the dog before. And as I'm getting closer and
Yeah.
closer to him with his back to me, I still don't see a dog.
Right.
Finally, I get to him and I go past him and turn around and I start laughing.
Oh, come on. What is it?
I think it was a Chihuahua,
Come on.
and I think that the certification label, whatever it was,
Yeah, they wear like a vest, kind of.
yeah,
Yeah.
whatever it was the label itself was bigger than the dog, and I couldn't stop laughing. And I remember saying to him, "That's your dog? That's your service dog?
Well,
That's
right,
your
sir.
service
Sir.
dog?"
Yeah.
And he said, "Yes." I was so uncomfortable going up through the marshal's area with a client with a service dog that was the size of my fist that I said to him, you know what? I'll meet you in the courtroom. I got to go in first. You go in separately. So I get to,
By the way, I know people, have abused that, service and the
yeah,
certifications. I've seen people with all different animals, even small ponies, Great Danes. Talk about the opposite of your client's dog, huge dogs, all different animals and so forth. And they do it, I guess, to get them permission to take them on airplanes. And
well,
they were
look,
definitely abused.
I'm not going to in any way denigrate the need that people might have for a emotional support dog or
Right.
service dog.
Oh, they
Um,
absolutely serve a purpose. They
yeah,
help a lot of
and
people.
who am I to say, whether or not somebody is in need of that or not? In this particular situation, though, given my client's physical disabilities, I was a little surprised to see a dog that was so tiny. I figured he would be with a dog that would steady him as he tried to walk.
Right.
In any event,
Yep.
he gets into the courtroom in the back, and the judge calls the case. And as I'm walking up to the podium, before I signal for him to come towards me, I hear this loud noise. Turns out the dog bit a lawyer
Oh no.
in the
Oh,
back of the courtroom. Somebody
oh,
apparently was, some lawyer went up to pet the dog or whatever, and the dog bit him.
well, oh my God. Yeah,
That was the
yeah.
interesting part of that
I
dog.
know a
So
lot of people don't like lawyers, but now dogs, I didn't realize we were their enemy too. Yeah. Or
so
maybe the dog was like, hey, dude, I'm working. Leave me alone. I don't bother you when you're working.
so
Yeah.
according to the client, what he told was that this dog could tell if he might be unconscious and lick him to warn him, which is quite remarkable. Anyway, the order goes on to say, and this is the important part, and this is why I mentioned this about a client lying to you about fundamental issues. Judge says during the course of litigation about defendant's medical concerns, i.e., his claim that he was not competent to stand trial, the government presented evidence showing the defendant was able to fly alone from South Dakota to San Diego without the accompanying service dog,
Right.
able to pick up his suitcase, place it on a scale and conveyor belt, walk through security with minimum use of a cane, and able to stand on one leg to put shoes back on without apparent difficulty. The government also presented surveillance video footage showing the defendant left home without his mobility scooter, walked his dogs without the assistance of a cane or walker, was able to pull trash cans back towards the residence without difficulty, and climbed onto a car to wash it. These surveillance videos and photographs presented to the court contradicted defendant's misrepresentations about the extent of his abilities. The court found the defendant competent to stand trial.
You know what you just described. We don't really hear that much in a criminal case. It's very much very common in civil cases, personal injury lawsuits, where someone claims they were, something fell on them in a store, and now as a result they're suing the store because they can't lift anything anymore. They need to help getting in and out of bed. They need this or they need that, and so the insurance defense firm that's defending the lawsuit, they'll put a private investigator on it. And I hear these stories all the time where some alleged victim who can't lift and can't do this and can't do that, that the private investigator for the defense insurance firm finds them on video doing all dancing, playing. I had a case, actually had a criminal case with injuries, and they started to sue my client. And our private investigators showed that this guy was playing golf 4 days a week, tennis 5 days a week, and going to the gym 7 days a week, which of course someone injured can go to the gym, and going out for dinner, a single gentleman out dinner and dancing and moving around basically 5, 6, 7 nights a week. And so these videotapes and private investigators can get a lot of good information, and it usually backfires on the person. Like in this case, it clearly did.
Yeah, and keep in mind that, when you are dealing with the federal government and the various agencies that are involved in investigating the case and prosecuting the case, the amount of manpower that can be committed and the amount of technology that could be committed towards finding out if your client is in fact, trying to fool everybody is enormous. So,
Yeah, yeah,
you know,
going up
it,
against the government.
it
Uh,
it's downright stupid is the best way to put it.
yeah,
To think that you can make these claims and then live your life in a way that you could easily be discovered. Well,
yeah.
in any event,
Well, wait, just to clarify for our listeners, the distinction between the reference I just made to civil cases where something fell on them in a store, they're suing for money, right? So when they sue for money, they're going to try to say they're severely injured and therefore they deserve a lot of money. So the insurance defense firms get the private investigators to prove that they're not injured. And when I said it backfires on them, that means they're not going to get any real money out of this case because they've now proven to the court that they're basically placing a lie on the court, and they're really not injured. So it hurts their financial result of their case. And in the criminal, as we were seeing in this example you're sharing, he was asking for compassionate release, meaning get out early because of these medical conditions, and it's hurting him because they're proving that all these conditions he's representing are just simply not true. And now
and the reality is, as the judge said at the early part of the order, that he does have serious medical problems. But the fact that he got caught exaggerating them and exaggerating it to the extent that he did worked against him. Whether or not the judge would have granted him compassionate release at some point in time is debatable, but certainly given what he has done and the fact that the court says later on that he has manipulated and lied about his medical conditions in the past, um, that
yep.
that damns him for eternity in front of this judge. And then further, the judge says in the order, the defendant has demonstrated a confidence that he can, as he told one victim, beat the system.
Oh boy.
At
Yeah.
least would demonstrate that he has done so by
Hola
exaggerating
amigos,
his medical circumstances. The court is not convinced that if he would be released, the defendant would be deterred from future criminal conduct. So, the moral of the story is um, don't lie to your lawyer.
Yeah.
Don't put your lawyer in a position of representing something to the court that could wind up being found to be untrue or even an exaggeration. And understand that when you are either in front of a jury or in front of a judge and you lie about something fundamental and you get caught on it, you're damned and you're done. And that's what happened to this particular defendant. And it taught me a very valuable lesson, which is even though they provide me with documents and even though they provide me with supporting information, I still have to keep a watchful eye. Now, obviously, I'm not saying every defendant or everybody I represent is dishonest with me. Quite the contrary.
Right.
Most of them are believable. And in fact, in many instances, clients can concede that, they have problems and the government has discovered them. But it's a valuable lesson. Fool me and you fool yourself.
Yeah. That's what I think I said earlier. I said, I said to clients, we're only as good as the information you give us. So there is a point where when we get a client, 99% of the time, we don't know that person. They don't know us. They were referred to us or they heard about us in the news. So they reach out. And there is a period, a dating period where we have to earn their trust or get them to be comfortable. And really, some clients may come in from the get-go and they're the smart ones that realize, okay, I'm hiring the best lawyer. I'm paying them money to do the great job for me, and I need to just fully open up to them. But some are untrusting at first, so they're holding back. And over time, they start to open up. And I get that. There is a little bit of a dance or a process that has to take place before clients will, feel comfortable to be completely honest. But I do have a lot of those conversations with clients about the fact that they need to tell me everything in order for me to get them the best possible outcome. But I want to stay on the topic of lying because as you spoke about this, and a lot of the beauty of these podcasts is they're very organic. There's not a lot of planning that goes into it. We just get on, we start talking about our cases, and it reminds us of other things that have happened in our very long careers. So you did exactly that. You reminded me of a case. Now, we were starting with bloopers, and that was funny, but this one is definitely not funny. A lawyer asked me to handle a case for somebody. He said it was a person who worked in their firm, a woman, their best producer in their law firm. Please help them. It was a pretty serious case. It was a theft. Actually, I'll briefly say, so this person was a personal injury lawyer. And basically, let's say they were settling a case for $100,000. That person, that employee who brought in a ton of business for this lawyer, would go to the client's home and sign the settlement papers there. And what they got caught for was that they would go to that client, instead of saying we're settling for $100,000, they would present them with paperwork that was fudged, and basically the client would get $80,000 and this employee would throw $20,000 of the $100,000 into their bank account. And it went on for quite a while, and it built up into a couple $1 million. It was pretty substantial, actually. So they eventually got caught, and they got arrested. So what happens is I wasn't the attorney at the time. This lawyer who had no right being in criminal court because they were a personal injury lawyer, they represented her in criminal, and they got to a point where they pled the case out, and she was going to surrender for a year in jail. But the judge agreed to give her 45 days to get her affairs in order. So the way that this particular judge did it was they said, we'll give you the year in jail, but if you want the 45 days to get your affairs in order before you surrender for that year, we're going to say that you're getting a 10-year sentence. And when you come back to this court I'm going to make this up, it was August 1st at 9 a.m. as scheduled, 45 days from now, you will automatically get your case reduced to the 1 year that we agreed to today. So the woman says, great. So this lawyer then, he's a personal injury lawyer, says, guy, I'm a little nervous about this hearing. Would you handle it for me as a favor? Well, no good deed goes unpunished. So I said, sure. So I'm going to handle the hearing. And the morning, this is a while ago when faxes were still very common. So I get to my office before going to court where I'm going to meet the client to surrender, and I have a fax, a whole bunch of pages from her. And it basically says, and it's a letter from a doctor, saying that she cannot leave her home, that she has a highly contagious situation, that it would be very dangerous for her to be in a courthouse, for everyone around her in the courthouse, all the personnel, all the other witnesses and defendants and so forth, the public. And to go to jail would be really, really dangerous too because of the confinement of a jail. Her highly contagious disease infection would just spread through the jail, and therefore the doctor is recommending that she stay home. So I go to court and I say, Judge, as you know, I'm just standing in for this attorney so-and-so for his client. And here's our situation today. She was supposed to be here at 9 a.m., or else she's going to get the maximum sentence. If she does show up, she gets the 1 year that she was agreed to. The judge says, well, what's the issue? Well, Your Honor, and if there's any kids listening to this episode, the parents, you might want to close their ears right now. I said, Your Honor, I got a letter from a doctor with photographs saying that my client has a highly contagious problem where she's suffering from anal warts. That's right, you heard that correctly, anal warts. So warts in her anus. It's even embarrassing just to say it. Like, it's, you can't believe this. You would think, well, this is so insane, no one would ever make this up, right? But in addition to that facts, the letter from the doctor, the client sent me several pictures of an anus with warts. I guess that is kind of funny, but it's really serious. So I have to stand in front of the judge and show the prosecutor, the court, these photographs of a female's butt and their anus with warts in it, and to explain why this is from the letter from the doctor, how highly contagious this is, et cetera, et cetera, et cetera. So the judge says, and he did exactly what I would do, and probably exactly what you're thinking, Mark, too. The judge said, let's give this doctor a call. So he calls the doctor, and he says, Dr. So-and-so, I'm reading your letter here in open court and understand, and I'm sure you're a qualified medical doctor, like it says on your letterhead. But tell me about your examination of the patient and how extremely contagious this is and dangerous for her to be around other people. And he says, well, I actually never saw the patient. He said, the doctor says, I never saw the patient. So what do you mean you never saw the patient? Well, it turns out that the patient called this doctor and faxed him the same pictures that she faxed me, which she probably found in some medical textbook or something, said it was her anus. And the doctor then wrote a letter, believe it or not, and the judge went ballistic. He had steam, as you can imagine, blowing out of his ears. And so he basically said, Doctor, you'll be hearing from the state attorney, and I'm sure the Board of Medicine will want to speak with you as well. The doctor actually admitted on the record he never examined this patient, he never met this patient, and yet he wrote this very serious letter. So at that moment, the judge told the deputies in his courtroom to go pick up the defendant and wear gloves and get her to the jail immediately. So it turned out that doctor actually he didn't lose his license over this because it was more of a professional irresponsibility than him doing. He's not a poor physician, but it was ethically, morally incorrect what he did. And so he did have like a 3-year PRN suspension, which is basically the probation for doctors, and he did eventually get his license back. And the defendant wound up getting the full 10-year sentence because she didn't show up at 9 a.m.
Wow.
Yeah, it's the most insane scenario I've ever been in. But we were laughing at them. When I first got that fax, I got to my office, it was like 7 a.m. to prepare for court, and I see it. I couldn't believe what I was seeing. And it turns out that it was all fake. It was all fake.
Wow. Well, I guess
Yeah.
to put it crudely, the client was a perfect asshole after all.
Yeah, she really
Uh,
was. She called me.
but
She got out, and she's called me since, and
oh my God.
she actually
Well,
apologized.
that goes to the point we've been making all along. the the problem of lying to your lawyer and the problem of lying to the court and what it ultimately can cause you. I had another situation it involves somebody obviously will not use his name. Um, Let me just back up and say this. Our clients come to us, and one of the first things we ask them, especially when they're facing a possible significant sentence, have you ever been arrested before? And, we don't have the same power that prosecuting or police agency has to run official records checks. I mean, there are ways that you can go about getting it, but generally speaking, we usually rely on what our clients tell us. And in this one particular instance, this client told me, and he was charged with fraud, a fraudulent scheme. And we were trying to work out a deal with the prosecutor. And the client told me that he had never been arrested before.
Which, by the way, for a defense attorney, that's a very strong, persuasive argument to make with prosecutors that, hey, our client has no prior criminal record. It's their first time, but if that's not the case, it's a real problem.
Right. So I went in, had a meeting with the prosecutor to discuss possible uh, plea. And during the course of it, I mentioned to the U.S. attorney that, look, my client has no criminal record. And I saw the U.S. attorney smile and back at me, and kind of a strange smile. And I interrupted and I said, Is there something," I said, "that's making you smile?"
Uh,
And he said, "Yeah, it turns out your client does have a criminal record." And I said, "Oh, really? And what was it?" And he pulls out an old edition of Sports Illustrated. And if you remember, since this is your alma mater, Tulane,
I remember the client, I remember the case, but our audience will enjoy it.
Tulane had a scandal back in, well, I guess it was in the 80s,
Well, it was a point shaving scandal in 84.
right?
1984, yep.
And involved, I remember, I think the main player was Hot Rod Williams.
Correct. Hot Rod Williams, who got uh, drafted, I think, #1 by the Cleveland, or the basketball team, Cleveland Cavaliers. Yeah,
Yeah.
they sent a big
Well,
time lawyer to New Orleans to represent him.
well,
Yeah,
apparently, there was this point shaving scandal that got discovered. And in the Sports Illustrated article about it, lo and behold, was my client's name as one of the architects of the whole betting scandal
yes, yeah,
while he was in school there. And the fact that he was criminally prosecuted. And I, I didn't know what to say.
yeah.
I was caught literally with my pants down because here I'm making a representation. It was part of my argument why my client should be treated more leniently. And it turns out this current situation was not the first time that he had a brush with
Right.
the law.
You know,
So
yeah, I always tell the client that if you misrepresent something to me that I then represent to the prosecutor is going to know that I'm not the one lying. They know, Mark, they know your credibility, they know my credibility, they know we do not lie or misrepresent, right? And so I said, it's going to backfire on you because they're going to know not only are you a liar, but you're even lying to your own lawyer. So it's really important that you tell us everything and be honest about it, you know?
yeah, and these situations unfortunately occur from time to time, and there's not a lot we can do about it other than to warn the client up front. Now, of course, when you're dealing with, people who come to you and they seem that they are, reasonable, intelligent people, likable, you have to handle it in a way that you're not insulting them,
Sure.
challenging them when they say something to you. But at the same time, you have to emphasize to them that unless you tell me the truth, we potentially could have a problem down the road. I need to know where the landmines are. I need so that I don't step on them and
Right. Yeah.
blow up your case.
Uh, you
And
know, go ahead.
they don't,
Sorry.
unfortunately, too many clients don't listen because, the reality is I do mostly white collar cases these days. And what I've discovered about a lot of white collar clients is they don't realize they're bullshitting you because they've bullshitted themselves to begin with.
They believe it themselves. Yep.
They believe
Yeah.
it
Yeah.
themselves, and that's a problem. So it's like peeling layers of the onion to try to get down to what the truth is.
Yeah.
And sometimes you never do.
Right. Sometimes they're not intentionally telling us a lie or they're not aware they are. For example, and I may have shared this in an earlier episode where I represented a prosecutor. My 60-year-old client had no prior record. And they said, oh, yes, he does. I'm like, really? So alleged, apparently, and they were smiling like that prosecutor kind of with you, and you just told a story. And they were smiling at me. They said, well, 45 years ago, I think he was actually like 13 years old, turns out he was on a tour, and again, I think I shared this once before, in London on a teen tour, traveling during the summer. Went by the palace. There was a little kiosk there. He bought a plastic sword, and he had got a police officer gave him a little piece of paper for that he brought home. His parents paid it. They thought it was like a little fine for something, and it turned out that it was a crime in London to have a sword of any sort, plastic or real, within 1,000 feet of the palace. And his parents just paid it when he got back to the United States, and it turned out it was actually a criminal offense. So my client, the prosecutor, was kind of smiling, joking, because they had a feeling that when my client told me they had no prior record, that they didn't really realize this was actually a crime, but it was. And we see those in at the state cases, like in DUIs. People tell us, "Oh, I did great on the field sobriety tests. I was perfect." And then we watch the video, we see them falling down drunk, falling down three times, and they don't remember it. Again, they weren't intentionally lying; they just didn't remember because they were so drunk, and their judgment was impaired, their memory was impaired. And the stress of the situation and so forth. I do find clients sometimes lie on one of the most common cases is domestic battery. It's very sad, but DUIs and domestic battery at the state level are very common. And sometimes defendants, to try to get a better fee, to get the lawyer to lower their fee, I find that they'll tell the lawyers in my firm, "Oh, the victim's not going to cooperate. This is going to be an easy, case for you guys. You'll put a couple hours into it. You'll get it dismissed because the victim's not going to cooperate." And they bring that up when they're trying to negotiate a lower fee. And we never fall for it because typically the engagement agreement will say, if they don't cooperate, the fee is X. If the victim does cooperate, then the victim is X times 4 or something like that. But they have all different motives for lying, sometimes intentional, sometimes not. But Mark, on a different topic besides lying, this is a case. I'm not going to get into details of the case because it wasn't the case itself through the legal system wasn't that interesting. But how it started, what led to my client's arrest, is I think hilarious. The prosecutor's office thought it was hilarious. Even the judge's legal assistant in the courtroom kind of giggled at it. So basically, my client was walked into a Starbucks very close to his home. He lived in a gated neighborhood, and when he walked into the Starbucks, in front of him in line was a neighbor. And there were several people in the Starbucks eating, sitting at tables, drinking their coffee and so forth. And there were several people in line. So it was relatively crowded. There were people behind the counter working at Starbucks. And this gentleman, alleged he's going to turn into a victim, says to my client very loud, he says to him, let's call him Bill, "Bill, so sorry to hear that you and your wife are getting divorced." And this was not public information at all. No one, to his knowledge, knew about this. They were still working things on their marriage and so forth. So Bill turns to this victim and says, "No, I don't know what you're talking about." And then he turns away from him. The victim again raises his voice and says, "Oh, come on, everyone in the neighborhood knows. We've heard about it. I feel really bad for you. Whatever you need, I'm here for you." And the guy again, Bills, is like, "No, not sure what you're referring to, but, have a good day." And a third time, this victim says it again, and he's even more assertive about, "We know she's leaving you. We know that you guys are looking at other properties, a house and this and that, and you got a lawyer. She's got a lawyer." And the guy was so upset, my client, Bill, that he reached over to this alleged victim and grabbed the toupee off of his head and flung it like a frisbee across the entire Starbucks, and it landed on someone's table, knocking over their cappuccino or whatever they were drinking. Yeah, frappuccino or something went splashing all over. So everyone around the courthouse called it the toupee case. Everyone knew this case.
Tell me your client was arrested for that?
He got arrested. That's the funny part. That's why it's a blooper, besides the fact that he flung a toupee like a frisbee. And some of our younger audience may not know, but it's basically when a man is bald and they wear a wig. The technical, I guess, the original term of that is toupee or a toupe. But yeah, he literally, the police, and when I talked to the police, I called them, they said, we felt horrible arresting him, but technically it is a battery. He did touch someone without their permission, and, we have to do this, so.
But here's the interesting argument, okay, just to be a little crazy here. He didn't touch him. He touched something that is honorably like a piece of clothing. Toupee doesn't belong to him. It's not part of his body, right?
Yeah, I know, but, the courts.
I mean, I'm just being facetious
right.
here. but it's just because the whole thing is so absurd that the guy, the problem in today's society is people are so litigious, and and in civil cases, and even in this, I mean, a guy like that, you take his toupee off. He embarrassed the hell out of your
That's
client.
right.
Obviously, you took his toupee off. He embarrassed you. I mean, all right, that's the end of it. Now you're going to make a police report? Come
Yeah.
on.
And
What a
yeah. At the end of the day, actually, we worked out where the two of them got together. They were neighbors, and they had to be neighborly. So they both apologized to each other because they both embarrassed each other. And they shook hands, hugged it out. The prosecutor agreed that the client would pay, I think it was like $500 in court costs, and the case went away. So that was cool. Another thing I was thinking about when we thought about, hey, let's do bloopers this week. When I was in law school, my dad said to me, lawyers need to play golf. So you need to play golf. I'd never picked up a golf club in my life, never been to a golf, course, but I was a tennis player. So my dad said, yeah, but you got to learn how to play golf. So for during my second year of law school, my dad gave me a set of used golf clubs. So I'm like, okay, I started playing a little bit, not much at the time. I've gotten into it in more recent years, but then I get a job as a prosecutor, and I get this case on my desk, and it's talking about this guy who has a small little golf store where he sells pre-owned, golf clubs, used golf clubs, and a case assigned to me that he just got arrested for grand theft, and I'm reading it, and I'm like, boy, this location seems familiar, the name sounds familiar, and all this, and this guy is basically selling stolen golf clubs that he's stealing out of people's garages and golf club. He's stealing them out, going to golf courses and stealing them out of the locker rooms and all this. And I'm like, oh, this cannot be true. It turned out that my dad bought them from this guy's store, who I now was assigned to prosecute. So I, as a prosecutor, am now aware that I'm playing golf with used golf clubs. And how random is it that I got assigned the case to prosecute? So, of course, I had to conflict myself off. Unfortunately, I really like those clubs. I had to
You had to
return.
give him back,
I
huh?
had to give them back.
There were evidence.
Yeah, it became evidence in the case. It was hilarious. And I called my dad. Of course, my dad had no idea. I'm like, can you believe I'm a prosecutor? You bought stolen clubs, and now yeah, it was pretty crazy. Another funny little story I have is I had a guy who, I'm not going to get too much into the details, but basically he had a business where he needed a lot of photography going on. And he knew someone through the community that was really down and out, had a lot of issues, financial, medical, personal. And this guy, my client wanted to help him. And so he said, look, do you know how to, are you any good at photography? And he's like, yeah, I'm actually okay with photography. He said, well, I'm going to start, help you out financially, give you some jobs. And so anyway, he let him take some photography professionally for his company and so forth. And he was doing a nice job with it. And then at one point, the guy said, I'd, really like to thank you for, giving me this income. It's been really helpful. Maybe I can do like, some photography portraits of you and your wife, and as a favor, and put it together in a beautiful album. So that'd be great. So they actually did it, and the couple, it was a beautiful, couple, happily married couple, been together for a number of years, and they said, we'd like to do some nude portraits, just for the two of us, and it's our personal thing that no one else will see. We'll have it as a, for us, our eyes only. So he said that I'm comfortable with that. So he did the pictures. A couple years later, say 5, 6, 7 years later, the guy basically kind of disappeared. He stopped doing the photography. My client didn't know where he went. He lost track of him. And then again, like 6 years later, he gets an email from him saying, hey, I'm really down and out and could use your help. And, my client writes back and says, I wish you well. I'm sure you'll get back up on your feet. Hopefully you can pursue your photography. You were pretty good at it. He gets an email in response. It's basically extortion, blackmail email, basically.
Oh, wow.
Yeah, basically saying, hey, you remember those pictures? I have all the negatives. And unless you, pay me for them, pay me what I'm asking, I'm going to go public with these negatives, these, nudes of you and your wife. And so the client calls me as a victim. And he says, "Guy, what can I do here? This is ridiculous. I helped this guy out, and now he wants to blackmail me. Like, the nerve of him." So I go to the police. I call my contacts at the police. I show them the emails. There were several emails in a row, very clearly extortion. And the cop says to me, "Well, Guy, yeah, I'm happy to meet with him." So we come in, we meet, and as the meeting ends, the cop turns to me and says, Guy, he's so adamant about pursuing this. This is the funny part, by the way. He said, the only reason I can think of in a million years why he's so adamant to get this guy arrested is because your client, meaning my client who's the victim, he must have a really, really small penis. Yeah, so to this day, it's been a few years since that case. The cop looks at me and says, "You always remember your client with the small penis?" Yeah.
What happened?
They did charge the guy. He got arrested. He had to turn over all his. We don't know if he had other film saved somewhere, but he represented under oath that he destroyed, gave us everything he had, and he had nothing left. And he did a short little probation and moved on with his life. But that was a pretty funny case, I thought.
Well, it's really amazing how stupid it is for somebody, and how desperate they must be for somebody to do what this guy did.
Yeah, yeah,
The easiest way to get caught is to put something in writing, and especially a lot of times when there's a ransom or there's an extortion, and this is going to lead in part into our next episode. It's going to be a fascinating episode. We're going to be talking about the Guthrie abduction.
Yeah, we are. And we're going to have a sergeant who's the head of the detective bureau on here talking about the investigation and yeah. Well, a couple other really quick ones. I'm not going to get into too much, but just I got to throw them out there because they're my funny memories of. I had a judge who finished the trial. What happened was the government goes first, ladies and gentlemen. If you don't know how it works in a criminal case, government goes first, and then they rest their case, and then the defense gets to start their case. Well, we had a senior judge, and for those of you that don't know, judges retire at some point in their career, and they can say that they'd like to be, picked up every once in a while as a senior judge. They get paid for it. So if a judge is on vacation, they'll cover their bench. If a judge is out sick, they can cover their bench. So I had a trial with a senior judge. It was a very short, maybe one-day trial. It was a few years ago. So the government goes through. This guy was pretty old, though. He was like 92. He was very sharp, we thought, and he had been a great judge. So the government finishes their case. They rest. And now, remember, I just said, now the defense gets to go, and then we present our case, and then the jury gets there. We do closing arguments. The jury gets to vote, guilty or not guilty. Well, right when the defense rested, said, "Judge, we're done with our case," the defense can now push their case forward. The judge looked at us in front of the jury and says, "Well, I find the defendant guilty, and we can go to sentencing now." So that's why I had to preface it with educating you guys. We hadn't even presented a defense yet. The judge took it out of the hands of the jury. He ruled before we even had our case. So the prosecutor looked at me and said, "Mistrial." And we said, "Judge, we need to approach." And it was time for him that was the last time, sadly, he was ever asked to be a senior judge. But there's been a few times where I've had to go to the bench. I just said we went up to the bench. We were polite. We don't want to embarrass the judge. So we went up to the bench and told him, "Judge, procedurally, we can't do it that way. We need to start over." And the judge was, "Oh, I'm so sorry." But other times I've been called to the bench. A judge once called me up to the bench in the middle of a trial. This is a different judge, by the way. And he said, "Hey, Guy," he said, "I've got a date tonight, and I know that you live in this certain area where there's a lot of great restaurants and stuff and a lot of good vibes and, energy. Where do you suggest I take her on my date?" And I'm like, "Wait, Judge, we're in the middle of a trial. We've got a jury here. We've got a witness on the stand." I can't believe it. But clearly he was not paying attention to the trial or the evidence. All he was thinking about, he was so excited about this great date that he had coming up. So I get called to the bench another time in a courtroom. This is in the Delray Courthouse, and across the street from Delray Courthouse is a beautiful tennis center, and there happened to be a big tennis tournament going on, and a professional tennis tournament. And we have about 400 people in the courtroom. It's called arraignment day, and the hearings are very quick. They take like 2 minutes per hearing, not even. So they work through these hearings really, really quick. There's about 400 people at the beginning of the day. We're down to about 200. The judge calls me up to the bench. He says, "Hey, Guy, there's that tournament going on and there's a really good match. He goes, meet me in the back. I'm going to go in the back. Come meet me there. We're going to go watch a tennis match. So I go, Judge, we've got 400 people. Well, now we have about 200 people. We can't just leave. He's like, I wear the robe. We're going across the street. We're not going to miss this match. I was the supervisor. So I go to the other prosecutors. I go to the public defenders and the private lawyers. I'm like, start working on your cases. The judge needs me on an emergency matter. We'll be back in about an hour. So he takes off his robe in the back. We literally go across the street, watch this great tennis match, come back. My final story about being called out was not in a courtroom or being called up to the bench, but it was actually in law school. I'm sitting there, we're in class, I'm really paying attention, it's very, very serious. And while the professor is lecturing us, he kind of roams the classroom. He walks up and down the aisles as he's lecturing. It was just his style. He goes to the podium at one point. He takes out a pen, a piece of paper. He writes something on a paper as he's lecturing, not missing a beat in his lecture. He folds the paper, and then he starts walking again, comes right up to my desk, and he puts the paper face down, it's folded closed on my desk, and then he continues lecturing, goes back. It's like another 30 minutes. I open it and it says, see me after class. I'm like, oh shit, what did I do? Like, I've been paying attention. I'm not doing anything wrong. I did my homework. So after class for 30 minutes, I'm sweating. I'm like, oh, this is not good, So afterwards, I go up to him. I'm like, yeah, but what's up, professor? He says, hey, I'm on the admissions committee in law school, and I saw on your application and your resume and your job history that you were a ski instructor in Aspen between college and law school. And I'm taking my kids on a ski trip this summer, and I thought I could get some advice from you on ski lessons for them and this and that. I'm like, Professor so-and-so, you had me, I was freaking out for the last half hour of class. So
a lot of fun stories.
A lot of fun.
Running out of time.
Yeah. It was a good one today.
We got plenty to tell, but I think our next episode is going to be fascinating because we do have a police officer. He's not associated with the investigation, which would be difficult for those people to talk about things, but he can give our listeners real insight into how these investigations take place. And where things may be at right now, because I know this is a matter of great public interest. So, ladies and gentlemen, until the next time, you're
free to go. Down Low Investigations is a sponsor of You're Free to Go. Behind every great criminal defense attorney is a great private investigator. That's why Mark and I use Down Low to investigate cases all over the country. Down Low can help you too. Whether you're running a background check on an employee or running a background check on a blind date, or let's say you need someone followed or some other type of investigative work conducted, Down Low is the way to go. Call Download Investigations at 561-843-1806. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fromston and Mark Nurek and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.